Good morning, good evening, and good afternoon. Welcome to our Crypto and Policy Show. This show happens right here live on X and YouTube every other Thursday at 12 p.m. Eastern Time. I'm your host, Jen Sanasie, here with my co-host partner at Paul Hastings, Renato Mariotti. Renato, Happy New Year.
Happy New Year to you, Jen. Good to be back.
Good to be back. We are 11 days away from Inauguration Day. A lot I think to happen for this industry in 2025. I just want to level set with you. I mean, what are you looking forward to as we get ready to have a new administration in the United States?
Wow. Well, for this industry in particular, this is one of the most interesting and exciting times that we've ever had. You're going to have new appointees, a new chairman of the SEC, we already know, but there'll be a new chairman of the CFTC as well. There may be some changes or combinations of agencies, and I would think a new regulatory framework for crypto. I mean, what an exciting time.
What an exciting time. Indeed, we are going to be talking a little bit more about what's going on with the CFTC later on in the show. Before we get to our first story, though, I want to remind everyone who's watching, we are live, like I just said, and you have the ability to interact with us. So if you have a question or comment for us, please just leave it below this video. We will be sure to get it to our guest, or Renato and I can discuss and opine. But let's get to our first story. Renato, you were just talking about regulatory clarity, and we're going to be discussing that in more detail right now. Coinbase has been given an unusual chance to skip ahead in a U.S. federal court dispute with the SEC. A judge granted the company's request to chase a narrow appeal of the regulator's accusations about trading crypto securities. Here to discuss this significant win with us is Coinbase Chief Legal Officer Paul Grewal. Paul, welcome to the show.
Thanks for having me, Jen. It's nice to see you. Good morning, Renato.
Good morning.
Of course, Happy New Year. Like I said, we are just 11 days away from Inauguration Day. Big things hopefully to happen for this industry in 2025. Paul, before we get into it, I just asked Renato this, but what are you looking forward to in 2025 as it pertains to crypto regulation?
What I'm most looking forward to is the chance to make our case and to work with constructive partners across the federal government to actually put sensible rules in crypto in place for the very first time. It's been a long 4 years, Jen. I think a lot of us in this space have endured, hoping that we would finally get to a time and place where we would have a constructive partner in the federal government to work with. And I think we finally have one.
It has been a really long 4 years, Paul. We've talked about it a ton on our programming here at CoinDesk. And this is what makes this recent development that we're going to be talking about now so significant. I want you to lay the groundwork for us here. Just talk to me about the significance of being granted an interlocutory appeal. Why is this important? What does it mean not only for Coinbase, but other firms in this industry?
What's remarkable about this decision by the court is that it granted really what is an extraordinarily rare remedy. And just to take a half step back, Jen, in our case with the SEC many, many months ago, the court made an initial ruling on the legal sufficiency of the SEC's theory that somehow in listing a dozen or so assets on our exchange, Coinbase was violating the federal securities laws. We believe, and we believe the law is clear on this, that none of these assets are the subject of securities transactions. None of these assets are subject to the SEC's jurisdiction. And so we brought an early motion in our case to dismiss the case on those legal grounds. Now, the court disagreed with us and laid out its reasons why. Ordinarily, when the court makes a ruling like that, there is an opportunity to appeal, but that opportunity only comes at the end of a case, after there's been discovery, after there has been further motion practice, and maybe even a trial before a jury. What the court did this week was say, we're not going to wait for all of that. Even though there are good reasons in most cases to follow an ordinary schedule for an appeal after all of the proceedings are completed in the trial court. In this case, things are different. There are important legal questions that impact not just Coinbase, but the industry. There are substantial grounds for disagreement with the order that the court issued on our early motion, among other courts in the federal judiciary. And given the significance and the weight of the issues, it's critical that a federal appeals court resolve all these differences of opinion, and provide some type of clarity about what the state of law is. And so for all of those reasons, the court granted us the permission that we sought to appeal this case to the Second Circuit without any further delay. It's a remarkable turn of events. It came over a very strong opposition and strenuous objection by the SEC. And we're grateful that the court gave such careful consideration to our arguments, and we look forward to making similar arguments to the Second Circuit in short order.
Yeah, it's hard to overstate how unusual and how big of a win this is for you guys. One thing that I thought was interesting, Paul, and I think it further kind of underscores the importance of the win, is that the court made clear that there's a lot of disagreement among judges about these issues, and essentially is really teeing up this case to be at the forefront of that and really be the case that brings these issues to a head. And how issues are framed can be very important for generating results. And from my perspective as an outside observer, Coinbase is put itself in a position to really be a leader for the industry. And I think one thing that I find interesting is you did that from the very beginning in this suit. I've never seen someone sued by the SEC before have such a public-facing approach to responding to that. In many ways, this order by the court feeds into and vindicates that strategy. How do you see that, and how do you believe that this positions Coinbase as a leader in this space?
Well, Renato, being transparent about our defense of this case is very much in line with how Coinbase operates as a company. And all that starts with the vision of our CEO, Brian Armstrong, for how we will operate as a leader in this space, not just in court litigation, but in our business as a whole. It started for us with our response to the Wells notice that we received even before this case was filed. A Wells notice is a formal notification from the SEC that it intends to pursue claims against a company or an individual. And in ordinary circumstances, and in most cases, the response to that Wells notice is something that's kept quiet, that's done in private, that is not shared with a wider audience. We decided to take a very different approach and publish our response to that Wells notice so that everyone could see and understand what we were saying and how we were saying it, and frankly offer alternative views or even criticisms if they disagreed. And it continued throughout our defense of the case, whether it was sharing our briefs with the public, whether it was immediately putting out the positions and statements of the SEC, whether it was flagging for the public's attention rulings by the court that had implications not just for Coinbase, but for others in crypto, including others who had been sued by the SEC. And so we just thought it was very important for us to be consistent in our approach to this litigation with the manner in which we've always sought to operate the company and run the business more generally. And we think it's also very consistent, frankly, with the ethos and spirit of crypto as a technology and crypto as a community. This is about transparency. This is about public disclosure. It's not about trying to quietly resolve cases in ways that advantage our company, but perhaps might disadvantage others. We want to win, but we want to win not just for ourselves. We want to win for the entire industry.
Talk to us a little bit more about that transparency. I mean, from an outsider looking in, the general public might see these court cases and think, oh, maybe this is not a firm that I want to interact with, right? And this industry is it's so important to build that trust and maintain that trust. How's being involved in these cases, albeit good, I guess, affected your trust with Coinbase consumers, and how is the company thinking about maintaining that trust as you move forward?
Well, we've been gratified that over the course of these lawsuits, our business has only grown stronger. We now have 52 million Americans or more who have owned cryptocurrencies in one form or another. And we just elected the most pro-crypto Congress and pro-crypto presidential administration in history. And so I think while it may have been the intent of the SEC to discourage people from involving themselves in crypto and doing so through Coinbase, I think the market has spoken as to how successful that has been. And we think it's important that we validate and vindicate that trust that our customers have put in us. And that's why we've been transparent. It's also why we've been so eager to take on fights that don't directly impact Coinbase, but are of great importance to our customers. We were quite supportive and quite involved in the case that a number of Tornado Cash users brought against the U.S. Department of Treasury when there were overbroad and unlawful sanctions issued against that privacy protective protocol. We've been quite involved in and directly engaged with the fight to get transparency around Operation Choke Point 2.0, which is the effort of the federal government, the FDIC in particular, to debank people in crypto and deny basic banking services to people simply for their involvement in crypto and use of this legal and well understood and well embraced technology in business. So our view has been that, yes, we have a primary responsibility, of course, to defend the company and to protect our shareholders' interests when these cases and investigations arise. But we also take a much broader view of our responsibility as the largest cryptocurrency exchange in the U.S. and a place where people have come to really view Coinbase as a leader on issues that go far beyond just our own particular interests.
So I'm going to ask a question that I think is on the minds of a lot of our viewers, Paul, which is a look ahead, really, at what we can expect, because I don't think at this point the Second Circuit Court of Appeals will be the decider regarding what a regulatory framework for crypto is going to look like, which is, I suppose, what the prior administration wanted. So what do you see? I mean, there's a lot of people in the industry who want the CFTC to be the primary regulator. Obviously, that was contemplated by legislation, including FIT 21. There may be a legislative framework. You could also just have rulemaking. And we also have an SEC chair nominee or designate who appears to be extraordinarily pro-crypto and very much welcomed by the industry. So what do you see in the months ahead?
Well, I think you're going to see a lot, Renato, happening all at once. The court cases very well could continue, at least for a time. There's no question, though, that a new administration will bring a new perspective on the wisdom of pursuing these registration cases where there are no allegations of fraud, no allegations of market manipulation. And we are hopeful that the new administration, once it's had a chance to look at these cases, will decide there are better ways to spend U.S. taxpayer money. Let's get a set of rules in place instead that would allow for registration, that would allow for companies to truly come in and register, in contrast to the situation we face today. And at the same time, I think a whole new set of rules could also come online, whether that's in the form of legislation passed by Congress for market structure, to deal with stable coins and address a whole host of other issues in a much more durable and much more sensible manner. And I think the agencies themselves are likely to initiate rulemaking to address how companies and individuals involved in crypto can, in fact, follow sensible standards for investor protection, but at the same time, continue to grow their businesses and provide new products and services that those 52 million Americans and many more all over the world expect.
I want to come back to the specific case for a second. Renato alluded to this earlier. The judge said that there is this question of law regarding the reach and application of Howey to crypto assets. And this has been very contentious in this industry over the past 4 years. I'm just curious, what the outcome here could mean for the application of the Howey test across the board. And is this something that is staying? Would this be precedent setting if there was an outcome here? Or do we really need, like Renato was just alluding to again, Congress to step in and say something concrete about this? How is that going to work as we move forward?
Well, there's the law as it stands today, and there's the law as it should stand going forward in order to promote innovation and protect this important industry. The Howey test has been in place for federal securities transactions for decades. And yet I think what these court cases all prove is that it offers, I think, very poor guidance to people trying to build lawful, compliant cryptocurrency projects, what the standard is, and how to think about the right way to develop those projects in ways that, again, protect investors, protect network participants, but also promote the innovation. I am confident, I'm absolutely confident that if and when the Second Circuit addresses these issues, they're going to find that the SEC's entire theory of how Howey applies to digital assets is broken. It's flawed. It runs counter to the intent Congress set out when it created the federal securities laws, decades and decades ago. But even if and when we win decisively on that issue, there's the separate question, Jen, of what should the rules of the road be going forward, so that, again, even if the current laws don't apply, what laws could apply in ways that strike a better balance between investor protection and innovation promotion. And that's why we think it's important not just to win in court, but to also step forward with our own ideas for what new rules could look like. And that's why we've done just that. Coinbase has supported industry efforts to propose new legislation that has made its way through the House already in the form of FIT 21, and we hope will soon make its way through the Senate. We've also been quite active in tendering proposals for rulemaking at the SEC, and we will continue to do that. So we want to build. We want to create, we want to construct. We're not just here to defend, past cases looking backwards in federal court. And we think we can do all of these things at the same time in ways that ultimately serve the crypto community's interests.
Paul, in addition to the need for a regulatory framework, there's also a need for education for the public. There's still a lot of disinformation regarding cryptocurrency and digital assets more generally. And I would say it's fair to say that there's a lot of skepticism, perhaps fueled by some of the activity that we've already discussed and the approach that the federal government had over the last 4 years towards this space. But also, I think perhaps that was reacting to skepticism the public had. What more does the industry need to do? Let's say once there's a regulatory framework, that will obviously help. Having regulation tends to help industries grow. But what more needs to be done by the industry in the years ahead?
Well, I do think education is critically important. It's remarkable that even as we sit here now in 2025, there are very few of our elected officials that still truly understand how these technologies work, what the shortcomings of the current laws are, and how we should go about fixing them. So we have focused our efforts, of course, on educating lawmakers and policymakers more generally on those issues. But there's also education that's critically important for the public at large, so that people have a fair and complete understanding of what they're getting involved in when they elect to buy a cryptocurrency token or stake some assets for the very first time. That's our challenge and that's our responsibility, and we take that very seriously. I'm extraordinarily optimistic that we can meet that challenge, because I think what we've seen over the course of the last several months, looking back to the election, is that Americans want cryptocurrency in their financial future. 80% or more of them are convinced that the current financial system doesn't work. They want alternatives, and they've now elected Congress people, senators, and even a president who understand that and are intent on making sure that we have sensible rules in place to promote these important alternatives. We're going to play our part. I think others in the industry are equally committed. And we're in this for the long haul. This is not just simply a matter of, a little bit of work over a short period of time. This is going to take months or even years of effort, and we're committed to that.
Paul, I want to change course slightly now. The last time you and I spoke, we spoke about Coinbase's claim against the FDIC over letters that asked banks to pause crypto-related activity. I know that there have been some recent developments there. Just talk to us as we go into the new year where that sits.
Well, the FDIC has engaged in some very troubling actions when it comes to debanking the crypto industry. And Nick Carter, Caitlin Long, and others have done incredible work in shining a bright light on these activities. This Operation Choke Point 2.0 effort was nothing short of an attempt to squeeze cryptocurrency firms in ways that were counter to law, outside of the public eye, and ultimately aimed at either destroying crypto or at least sending it outside the United States. When Coinbase learned that bank regulators were telling the banks, don't bank crypto, don't provide access to crypto services to your customers, or else we're going to take retaliatory steps against you. We thought it was important as a first step to understand what are they telling the banks, what actually was going on here. And so we served what's called a Freedom of Information Act, or FOIA, request on the FDIC, asking them to produce these documents. We are entitled to them as a matter of law. This is a government agency acting in all of our interests. And so ordinarily, regular citizens and companies like ours can make these requests and expect to get those documents without any real challenge. In this case, the FDIC threw up every roadblock. It first objected to the requests entirely. It then forced us to go to court. We had to file a federal lawsuit to get the FDIC to comply with our requests. And when we did that, we eventually got documents that were blacked out, redacted, had whole pages withheld. And so we had to go back to court and get yet another order compelling them to follow the law. And finally, when the documents came, what we came to learn is that in example after example, bank supervisors were telling the regulated banks that they oversee, don't touch crypto, don't do what you have proposed to do in terms of providing basic access to crypto services for your retail customers, or else there's going to be a price to pay. You might suddenly find yourself receiving an unexpected audit. You might suddenly see in your mailbox 90 or even 100 questions about all of your operations that need to be answered within a matter of days. That's extremely concerning. That's troubling, because that's not how the law provides for the FDIC to supervise these banks. And that's not what the FDIC is supposed to be doing. They're supposed to be operating in good faith. And so we have been aggressive in pushing for a full accounting of what happened. We were pleased to be able to share the initial production of documents that we received from the FDIC and a follow-on production that came more recently. And we're confident that when policymakers, people on Capitol Hill, Congress people in charge of committees with oversight authority understand what has been produced, they're going to have their own questions. They're going to want to have hearings. I'm equally confident that when the federal district court comes to learn it was misled as to the completeness of the initial productions for the FDIC, and perhaps that there were efforts to avoid having to produce a full set of these materials as they were required under law, there are going to be hard questions asked. And so there's more to be learned over the course of the next several weeks and months, but we're going to keep at it because we think it's important that the story be told.
One question that I had, I think, coming off of that is, there has been, I think if we look backward, the federal government and its role in how it, this campaign against the crypto industry, I think is not really known to the public. And I'm curious, obviously there's a lot of excitement ahead. There's a lot to look forward to. How important is it from your perspective to look backward and shine a light on what occurred? And are there any changes to the law that we need to have to make the actions of the federal government more transparent? I mean, you are not the first litigant to complain about FOIA and FOIA exemptions, which that particular exemption that they use, Exemption 8, has been read very broadly by courts. So I'm curious what you think about that.
Well, I think to get to solutions, Renato, you have to first admit that you have a problem and understand the scope of the problem. And right now, we still have an agency of the federal government refusing to say what they've done. It's I think, obviously important for the crypto industry, given that we were specifically targeted by the FDIC in this way. But I think the thing to bear in mind is that this goes beyond just crypto, because if it's crypto today, what industries, what lawful activities will it be tomorrow? It can't be the case that when Americans want to engage in lawful activities and conduct lawful business, that if those activities or business are somehow out of political favor with the regulators or powers that are currently in office, they somehow suffer or pay a price for that. That's not how America works. That's certainly not how American law works. And so I think it's critically important, not just for this industry, but for every industry and every community, to understand what is this government doing in their names, and how can we make sure that these types of exemptions and rules aren't abused by regulators in the future in ways that deny us basic transparency into how our government is operating.
Paul, just before we wrap up, I'm just so curious, we're talking about these suits that don't only have major implications for Coinbase, but the entire industry. And I can't imagine that it's cheap. I imagine that your team has grown a lot. I imagine you've spent lots of resources on defending not only Coinbase, but the industry here in the United States. Is there a number you can put to that? And it's okay if you don't have one top of mind, just out of curiosity.
It's not a small number. I'll put it that way, Jen. But look, I will say this. I'm grateful that I work for a CEO, Brian Armstrong, and a board of directors who have a broader sense and understanding of their responsibility than just what impacts Coinbase and what we need to do for our shareholders. Our shareholders' interests are obviously critically important, but leadership of this company has made it very clear that we will put whatever resources are required and spend whatever it takes to shine a light where we see the industry under attack, and that's what we're going to continue to do.
Paul, thank you so much for joining the show. It is always a pleasure chatting to you about progressing this industry forward, and I'm sure that we will chat to you soon.
Good to speak to you both.
That was Coinbase Chief Legal Officer, Paul Grewal. All right, Renato, we are still here. We just spoke to Paul Grewal. I'm going to let our audience know you have the ability to ask us questions and engage with us. So put your questions and comments under the video. We will get to them throughout the broadcast. But before we move to our next story, Renato, just curious on your reflections from that conversation with Paul.
That was really interesting. I think it's got to be very vindicating for Paul and for Coinbase. I mean, he's still involved in litigation and he represents Coinbase. So he has to be careful, I think, with his words. But Coinbase took what was, I would say, a very innovative and aggressive strategy. You used the term Wells notice. That is essentially when the SEC says, we're going to sue you. When that happens, it's done in private, and typically people want to keep that private, and they engage in those conversations behind closed doors. And to go and publicly say what the SEC is doing is wrong, we're going to fight it. We're doing this on behalf of all of you and of the industry, and really taking a leadership role on behalf of the industry. It's something that we haven't seen really before. I certainly haven't seen it in my lifetime. And now what we're seeing is the fruits of that. Now they're going to get their day in the Court of Appeals, but more importantly, we have a new road ahead and a new era where we literally are going to be discussing what the new regulatory framework is for crypto and who that's going to be. So this is such a big day for the industry, but it's also a big day for Coinbase, who really, I think, showed some leadership for the industry. And should be commended for doing that.
Yeah, I completely agree. And that last question there, I can't imagine this is cheap. I can't imagine that. I can only imagine it's very resource intensive. I think back to when it was revealed that Ripple had spent $200 million defending themselves against the SEC. So that's just a little bit of a benchmark there when we're thinking about how much, Coinbase may be putting forward to progress the industry, not only for themselves, but for everyone else who is trying to make it work over here in the United States. Now, let's move to our next story now, Renato. From the SEC to the CFTC, this week we learned that Gemini Trust Company agreed to pay a civil penalty of $5 million to settle charges in connection with statements it made about its Bitcoin futures contracts in 2017. Just break down for us what's happening here. I know that Gemini has not admitted to or denied anything. They're just paying this. They're settling the case. That means they're not going to go to trial on January 21st like it was originally planned. What's happened here? Are they just tying up loose ends before the next administration comes in?
Well, good question. I mean, what the allegations are, just so people understand, is Gemini had made an application to the CFTC to be what's called a DCM, a designated contract market. This is in relation to a Bitcoin future that they were offering. So a futures contract is essentially something you buy that means that you'll, at the end, if you buy the contract and hold it till the very end, you'll actually get Bitcoin. And so it's a way of predicting and locking in the price of Bitcoin in the future. And they made some statements that the CFTC has alleged are false throughout, and in their order, in which imposed the $5 million fine, they walked through various false statements that Gemini had made about, for example, whether or not they had made certain loans to the customers, whether the customers were engaging in transactions that were self-funded, that, whether they were able to trade against themselves. So a variety of different alleged false statements. And I think, what this suggests to me, Jen, first of all, I think Gemini had to make a calculus here. They had a trial coming up, as you suggested. They decided that the allegations ultimately were the sort of thing that may not necessarily disappear with the new administration coming in January 20th. These are the type of things that, no matter what the administration, making false statements to a regulator is something that most people tend to punish when they're a regulatory body. And this was, I think they must have thought this was a fair result. It's interesting because obviously for a lot of folks in this industry, they've been trying to not hurry along matters, not reach resolution until they get to a new administration. And I think, Gemini felt like it was important to turn the page, and now they have. And I think what it really makes one wonder is, what will happen with the various other cases that are still pending of the CFTC and SEC have.
This brings up a question. We talk about false statements to regulators, but there's also the general public, your customers. And I'm curious, Renato, how much crypto firms should be thinking about or think about, I know you have crypto clients, about their marketing material and the claims and statements that they make and how that might be seen by regulators.
That is got to be the most central thing you're thinking about. I mean, if you're doing business in this space, you have to carefully vet the statements that you're making to your customers, the statements you're making to the public about your product. When we had Paul on a moment ago, he made a point of saying these allegations against us do not suggest we've committed fraud, do not suggest we've made any false statements. And I think that's the reason that so many in this industry were appalled by some of the stance that the SEC had taken in this case and some others. But there's no question that no matter who's in charge of the SEC or the CFTC, if you're making false statements to them or to your customers or you're committing fraud, they're going to come after you. And it's important that you make sure that you vet your statements carefully so there's no misunderstanding about that. Because even if you think that there's a good reason to suggest that what you're saying is accurate, if it could be taken differently or a regulator could have a different view, you'd rather figure that out on the front end rather than pay, you had mentioned some big numbers a moment ago, pay lawyers millions and millions of dollars and have to deal with a very difficult suit against the government.
Yeah, well, I mean, you brought this up just a second ago. Some people might be waiting out to see what happens with their pending SEC suits. Gemini is facing another case with the SEC. On that note, I know you and I have talked about this, Renato, but I think it's worth bringing up again for the audience. How possible is it that we get a new administration, we have a new SEC, they take a look at pending cases and they think these are actually not relevant to us anymore, and they just go away?
I do think some may. I wouldn't be surprised if Mr. Atkins, who's going to be the new chair of the SEC, assuming that he's confirmed, it takes a look at, for example, SEC versus Coinbase, and decides that is not in the public interest. And in fact, that's one of the many reasons why that move to the Court of Appeals is a good thing for Coinbase. But I do think that won't happen in 100% of circumstances. And
Yeah.
so if you are litigating right now against the SEC or CFTC, I think you really need to consult with your legal counsel and make sure, what do we think is going to happen? But a lot of people, I think, are definitely waiting in a wait and see mode because they're hopeful that a new administration is going to clear the decks of some of these matters.
All right, let's move on to another piece of CFTC news. We learned that CFTC chair, Rostin Benham, is going to be resigning on January 20th when President-elect Donald Trump takes office. This is not really a surprise, but talk to me about this. I mean, do we know who the next CFTC chair is going to be? Will it be one of the commissioners as an interim chair until President-elect Donald Trump makes an announcement? What happens next?
Great question. We don't know who the next the CFTC chair is. I think that's interesting. Brian Contens, who used to be a commissioner during the first Trump administration, did a lot of work with Andreessen Horowitz. He is rumored to be the new CFTC chair, but there's been no announcement. from the president-elect. So, I think you can't count your chickens before they're hatched there. There are plenty of other strong candidates. Caroline Pham and Summer Merzinger are Republican appointees who are chairs now. People have talked about Josh Sterling and others. So there's plenty of other names swirling around, and we'll have to see what happens there. But we'll definitely have new leadership. And Jen, one thing I thought was so interesting. We just saw a goodbye speech, essentially, a state of the commission address, keynote address by Chair Benham, and it was very interesting to me that he took a role. He tried to suggest that he had taken a friendly role towards the industry during his 4 years. Now, folks in the industry really did like the CFTC more than the SEC.
They
It's a
did.
low bar. But it's interesting because you could tell from some of his public statements throughout the last 4 years that Benham really wanted the CFTC to take a leading role and really wanted to be more friendly towards crypto. But I think he ultimately was hemmed in and really did not do as much as a lot of people in the industry wanted. And
Yeah.
I don't think that his statements are going to ring true for a lot of the people who are viewing this program right now.
Yeah, that's interesting. I mean, there was kind of this like struggle between the CFTC and SEC. I know the CFTC was requesting more resources to start understanding the space, to continue their actions within the industry. What do you think is going to happen? Is that going to balance out? Do you think that the SEC or the CFTC, one of them, is going to have more of a stronghold when it comes to regulation and enforcement over this industry? Do you think they're going to be able to work together? What do you see in your crystal ball?
It's interesting. I've done a lot of work with and against the CFTC over the years. It's been a big part of my practice, and they're almost like the little stepchild of the SEC. They have a much smaller budget. They have fewer people. They've always sort of been in the SEC's shadow. And they're within the CFTC, a lot of the leadership there will tell you when the cameras aren't rolling that they really want to regulate this space. And a lot of people in the industry want the same thing. So is it possible that the CFTC will get spot authority over crypto? Yes, that is possible. Spot regulatory authority, yeah, it's very possible. That would be a big deal. If they don't get an increased budget, it's going to mean that the CFTC is going to be, going to do some things, but they're going to be limited in the amount of work that they can do regulating the space. But I would assume that they would get some funding for that. Another idea that has been tossed around is regarding, particularly since the announcement of that Doge initiative, is maybe a combination of the two agencies. I don't know how that would work. I think the SEC would be more enthusiastic about that than the CFTC. And of course, we do have a very friendly SEC chair, so it's certainly possible, as you suggested, Jen, that they can work together. I had sat down recently with Commissioner Pham, and she had told me that there are some mechanisms by which the SEC and CFTC could work together right away. So I do think it's possible that we'll just continue to see cooperation, particularly in an interim period where you may have an acting chair prior to the confirmation of a CFTC chair. So we'll have to wait and see.
What a year we have ahead of us, Renato. What a year to be doing this show. I am excited to witness the developments that are ahead of us with you and unpack them here on the show. So thank you for co-hosting this with me. And I know that it's only going to get bigger and better.
I'm excited. Our next show is going to be after the inauguration. So there's going to be even more to discuss. So I'm excited. This is going to be quite a year ahead for this show.
Of course, and thank you to our audience for listening, for chiming in with your comments today. We are here every other Thursday at 12 p.m. Eastern Time. We always have spectacular guests who can unpack the future of crypto regulation with us on this show. Have a great day, and we'll see you next time.